Կարող ենք սկսել, եթե խնդրեմ այցնել մի փոքր ուշացումով, բայց մենք պատրաստ գործընկերություն հանուն բաց հասարակության կազմակերպությունների Բարև ձեզ, սկսում ենք գործընկերություն հանուն բաց հասարակության համագործակցություն կազմակերպությունների խմբի կողմից նախաձեռնած քննարկումը։ Շնորհակալություն գալու համար, շնորհակալություն Հայաստանի Հանրապետության կառավարության ներկայացուցիչներին եւ մեր գործընկերներ հասարակական կազմակերպություններին եւ լրագրողներին նաեւ ներկա գտնվելու համար։ Մենք այսօր քննարկելու ենք մի թեմա, որը վերջերս բավական ուշադրության ներքո էր, ոչ միայն քաղաքացիական հասարակության Հայաստանի, բայց շատ ավելի լայն համայնքի, միջազգային եւ հայաստանյան։ Դա խոշտանգումներն են եւ մասնավորապես խոշտանգումներից դաշան վերաբերմունքից ազատ լինելու իրավունքը։ Վերջերս հրատարակվեց Եվրոպայի խորհրդի CPT-ի զեկույցը։ Դա եղավ նոյեմբերի սկզբին, նոյեմբերի մեջ։ Նաև վերջերս ՄԱԿ-ի կոմիտեն խոշտանգումներից զերծ մնալու Committee Against Torture նաև լսեց Հայաստանի Հանրապետության 4-ամյա պարբերական զեկույցը այս հարցերին նվիրված։ Դրանից հետո Հայաստանում արդեն Երևանում մենք հնարավորություն ունեցանք լսենք քրեակատարողական հիմնարկների մոնիտորինգային խմբի ամենամյա զեկույցը։ Ասելս այն է, որ բացի նրանից, որ բավական մեծ ծավալով ինֆորմացիա կա այս հարցի շուրջ, նաև կա այդ թե միջազգային եւ թե հայաստանյան հանրության հետաքրքրությունը այս շատ կարևոր հարցին եւ մենք այսօր ուզում ենք անդրադառնալ թե այդ տարբեր զեկույցներում խնդիրներին եւ մասնավորապես թե այն այլընտրանքային զեկույցին, որը որ հայաստանյան մի քանի հասարակական կազմակերպություն, ներառյալ մեր կազմակերպությունը, բաց հասարակության հիմնադրամները կազմել էին եւ ներկայացրել էին ՄԱԿ-ին այս հարցի շուրջ։ Բայց մինչև գործընկերներին, որոնք այստեղ ներկա են, որոնք որ այս զեկույցի մասնակցելուն, այս զեկույցի պատրաստելուն մասնակցել են, ես օգտվելով առիթից, որ շաբաթ օրը Մարդու իրավունքների պաշտպանության օրն էր, եւ որ մենք արդեն տարի ենք փակում, հաշվապահական լեզվով ասած, կուզենայի մի քիչ անդրադառնալ այդ մարդու իրավունքների հաշվապահությանը, եթե կարելի է ասել, եւ այդ ավելի լայն հարցի, ավելի մեծ հարցի, թե տենդենսներից, թե նվաճումներից կամ ձեռքբերումներից կամ հակառակը այդ տեսակետից մեր այսօրվա խնդիրը նաև փորձեի տեղադրել եւ նաև հրավիրել այդ տեսակետից քննարկումների։ Ցավոք այս տարի երկրի քաղաքացիների եւ շատ ընտանիքների համար եղավ շատ մեծ ցնցումների եւ կորուստների տարի եւ մենք ունեցանք թե ապրիլյան պատերազմը եւ թե նաեւ հուլիսյան իրադարձությունները, որոնք որ մեծ ցնցումներ էին մեր երկրի համար։ կարելի էր նախատեսել, կարելի էր այդ ցնցումներից խուսափել, այդ հարցերի պատասխանը երևի ոչ ոք չգիտի, բայց որ այդ ցնցումների արժեքը եւ այդ ցնցումների այդ նեգատիվ ազդեցությունը կարող էր լինել ավելի քիչ, դա ակնհայտ է եւ դրա մասին թե մենք թե բազմիցս քաղաքագետներ, մարդու իրավունքների պաշտպաններ, հակակոռուպցիոն դաշտի մասնագետներ բազմիցս թե բարձրաձայնել ենք, թե խոսել ենք այսպիսի միջոցառումների ժամանակ, խոսել ենք այսպիսի աշխատանք կատարելով մոնիտորինգային, վերլուծական եւ տեսնելով, որ իսկապես աննման մեծ եւ թանկ գին է նստում այն, որ դեռ էֆեկտիվ չի պայքարը գնում կոռուպցիայի դեմ եւ իրավունքի պաշտպանության, որը որ բերում է մեծապես վստահության ջլատմանը եւ քաղաքացիների քաղաքական process-ներին որոշում կայացնելուն անմասնակից լինելու։ Դրա հետևանքով արդեն լինում են խորտկումներ, որոնք որ լինում են։ Այնպես որ այս տարվա մեր ապրածը, վերապրածը ինչ որ չափով ինձ թվում է նախ մեր համաքաղաքացիներին այդ մասին շատ ցայտուն ձևով ներկայացրեց, բայց նաև հնարավորություն տվեց որոշում կայացնողներին կարող է պատահի մեկ անգամ եւս գնահատել, վերագնահատել այդ ամբողջ գները, որ մենք ցավոք վճարում ենք, եւ միգուցե փոխել մոտեցումները եւ ավելի հաստատակամ եւ ավելի մեծ կամք դրսևորելով պայքարել այդ նեգատիվ երևույթների դեմ մեկ անգամ եւս ցավոք պետք է ասեմ, որ ցավոք մինչ այս օրս մենք չենք տեսնում դրա արտացոլումը եւ ժամանակը դրան անդրադառնալու կարող է երբեք չունենանք, եթե ոչ հիմա։ Վերջի քննարկումը, որին մենք մեծ մասը այստեղ նստածների մասնակից էինք Ժնևայում, երբ որ քննարկվում էր պետական զեկույցը խոշտանգումների մասին, մեզ համար քաղաքացիական հասարակության համար ուսուցանելի էր երկու տեսակետից, ինձ թվում է իմ գոլեգաները դրան համամիտ կլինեն, այն տեսակետից, որ մենք մեկ անգամ եւս հասկացանք, որ մեր ասածները, մեր դիտարկածները, մեր ռեկոմենդացիաները մտածածի չեն եւ նույն խնդիրները, նույն հարցադրումները, նույն համարյա բառացի ռեկոմենդացիաները մենք լսեցինք նաև ՄԱԿ-ի կոմիտեի կողմից։ Դա իհարկե հույս է տալիս, որ մեր աշխատանքը բավական բարձր մակարդակի է, ոչ միայն ասենք մեր գնահատելով, բայց ավելի բարձր ստանդարտով եւ մեզ հնարավորություն է տալի ել ավելի համար պնդել մեր ռեկոմենդացիաները։ Մյուս կողմից էլ իսկապես մի քիչ ավելի ոչ մասնակից, բայց ավելի դիտորդի դերում եւ դուք կարող եք նաեւ դիտել այդ քննարկումը, որ կա ՄԱԿ-ի կոմիտեի վեբսայթում, մի քիչ ավելի կողքից նայելով մենք հասկացանք, որ իսկապես նաեւ ճիշտ է այն, որ խնդիրները շատ կարևոր են եւ ցավոք դրանցից մեծ մասը ստագնացիայի մեջ են վերջի քանի տարիները։ Մենք ակնկալում ենք իսկապես նաեւ այս 4-ամյա զեկույցից հետո ավելի մեծ կամք դրանք լուծելու եւ անդրադառնալու հարցերին, որոնք որ իսկապես թե հրատապ են եւ թե լուծելու համար չեն պահանջում այն մեծ ներդրումները, որոնք որ կարևոր խնդիրները շատ ժամանակ պահանջում են։ Դրանք պահանջում են միայն ստանդարտին համապատասխանեցնելու թե օրենսդրությունը եւ թե քաղաքականությունն ու պրակտիկան։ Ես հույս եմ հայտնում, որ մեր այս զեկույցը հնարավորություն կտա բոլոր կողմերին թե լսելու այդ հարցադրումները եւ թե մասնակցելու քննարկման եւ ես շատ շնորհակալ եմ, որ մեր գործընկերները պետական մարմիններից նաեւ այստեղ են, դա իսկապես ոգեշնչիչ է, որ քննարկումը եւ հարցերը կարեւորվում են եւ ես զեկույցը արդեն ավելի ներկայացնելու եւ հարցերը ավելի մանրամասն ներկայացնելու մեր առաջի բանախոսին եմ տալի խոսքը, պարոն Դավիթ Խաչատրյան։
Բարև ձեզ։ Ես շատ կարճ կներկայացնեմ, իրոք ողջունել է պետական մարմինների ներկայացուցիչների այստեղ գտնվելը եւ մեր Ժնև կատարած այցը եւ նախապատրաստած հաղորդումները, ռիպորտները, դրանք պատրաստվել են ՄԱԿ-ի խոշտանգումների դեմ կոմիտեի եւ կառավարության Հայաստանի հետ դիալոգի որպես մաս, երկխոսության մաս։ Եվ ենթադրում եմ այստեղ այդ երկխոսությունը պետք է շարունակվի, դա ամենևին չի նշանակում, որ մենք այն ամեն ինչը ինչ-որ մեր կարծիքն է, մենք դա հայտնելու ենք, այնպես ինչպես որ կարծում ենք։ Եվ խոշտանգումների հետ կապված ես պարզապես ներկայացնեմ այն բացերը, որոնց հետ կապված մենք ուշադրություն ենք դարձրել եւ առաջարկներ ներկայացրել եւ մեր մտահոգությունների գրեթե բոլորը դրանք ներառվել են եւ ընդունվել են զեկուցողների կողմից եւ երկրին ուղղված մեր ասելով ես նկատի ունեմ գործընկերություն բացասարության այդ գործընկերության մտահոգությունները բոլորը ներկայացվել են որպես նաև ՄԱԿ-ի խոշտանգումների դեմ կոմիտեի մտահոգություններ եւ շատ ամփոփ եթե ներկայացնեմ դրանք լրիվ տեղավորվում են այն մտահոգություններին, որոնք ունի եւ CPT-ն, այսինքն Եվրոպայի խորհրդի խոշտանգումների դեմ կոմիտեն, այսինքն դրանք այն պարտավորություններ են, որ մենք ունենք Եվրոպայի խորհրդի առջեւ Եվրոպական կոնվենցիայի շրջանակներում, դա առաջինը քրեականացումն է խոշտանգումների եւ ունեցանք 2015 թվականին գիտեք քրեական օրենսգրքի փոփոխություն տեղի ունեցավ, որով որ առաջին հոդվածին համապատասխանեցվեց դա դրական քայլ էր իրոք, առաջին հոդվածը խոսում է նրա մասին, թե ինչ է խոշտանգումը, ՄԱԿ-ի կոնվենցիային համապատասխանեց, բայց դա այնուամենայնիվ շատ հեռու է բավարար լինել, որովհետեւ մենք ասենք իրոք մենք դրական շատ մեծ քայլ կատարեցինք։ Նախ եւ առաջ մյուս ձևերը վատ վերաբերմունքի չքրեականացվեցին, ինչը հանգեցնելու է նրան, քանի որ նման վատ վերաբերմունքի մյուս դրսևորումները, մասնավորապես անմարդկային եւ արժանապատվությունը նվաստացնող վերաբերմունք եթե դրանք քրեականացված չեն, ապա ինչպես են իրավակիրառները պարզելու թե արդյոք սա խոշտանգում է թե վատ վերաբերմունքի մյուս ձև է եւ այստեղ մեղադրյալները, կասկածյալները օգտվելու են չփարատված կասկածների շահեկան մեկնաբանման, այսպես ասած, կանոնից եւ իրավունքի բոլոր բացերը մեկնաբանվում են գիտեք օգուտ մեղադրյալը եւ ըստ էության չի գործի այդ նորմը, ինչպես չի գործել ասենք տասնամյակներ ի վեր, բայց քրեականացումը ինքնին բավարար չէ։ Գիտեք, որ պահանջում է կոնվենցիայի ներքո արդյունավետ եւ անկախ քննություն խոշտանգման մասին բոլոր հայտարարություններ։ Եվ սա հենց այն կետն է, որտեղ մենք ունենք այնպիսի բացեր, որոնց մասին չենք կարող պարզապես ասել, չէ թե դա ձեր կարծիքն է, սուբյեկտիվ է եւ այլն։ Մենք ունենք հստակ վիճակագրություն։ Նախ, քան եւս հարցերը տրվեցին խոշտանգումների կոմիտեի անդամների կողմից կառավարությանը Ժնևում, օրինակ քանի դեպք ունենք, երբ որ Հայաստանի դատարանները այս քանի տարվա ընթացքում անթույլատրելի ճանաչած կլինեն ապացույցը այն խոշտանգման արդյունքում ձեռք բերված լինելու հետևանքով։ Մենք գիտենք, որ 0 է կամ շատ քիչ ունենք այդպիսի չնայած պատասխանն է, գիտեք, որ մենք այդպիսի վիճակագրություն չկա, բայց մենք շատ քիչ նման վիճակագրություն ունենք։ Եվ խնդիրը սիստեմիկ խնդիրների մասին է, որը մենք մեր զեկույցում նշել ենք, եւ խոսքը վերաբերում ոչ միայն ապացույցների թույլատրելիության, այլ ընդհանրապես, երբ որ խոշտանգման հետ կապված մարդը հայտարարություն է անում, եւ սա ոչ միայն վերաբերում է խոշտանգման, ենթադրյալ փաստերին, սա ես կարող եմ հստակ ասել վերաբերում եւ ընտրական գործընթացներին եւ կոռուպցիոն եւ մասնավորապես որ տեսնում ենք կարծես թե իրավական բավարար
in order to charge an official for a corruption offense or for the chair of an electoral committee to be prosecuted, a greater standard of evidence has to be met. So for torture, we monitored the situation together with the Helsinki Citizens Assembly Manager Office, and we saw that we don't have any defendants, whereas in ordinary cases, for example, in cases of resisting to a representative of the power, 316 cases are easily initiated, prosecuted, and charged. So the committee spotted this as well very clearly by saying that the committee is concerned about the high standard that is expected, that is followed in prosecuting cases based on torture allegations or ill-treatment allegations. And then we see that from 2015, when this crime was criminalized, when it was aligned with CAT Article 1, there have not been any convictions. It's been a year and a half, as far as I know. It was presented to the torture committee that 18 cases have been prosecuted and that 12 have been discontinued, and in 6 of the cases the investigation was still underway. Anyway, that concerns allegations made beyond criminal proceedings. Now, the systemic problems are not limited to the law enforcement system. It also has to do with the judiciary. The judiciary makes it clear that inadmissible evidence will be struck out and it will not be used in the judgment. Clearly, there's no demands by the judiciary for inadmissible evidence. Inadmissible evidence is not going to emerge during the investigation. That's not my position, that's the position of the European Court. It says when the evidence is going to be used, evidence is going to be used to convict. It's a heavy incentive for collecting the evidence using inappropriate methods of investigation. And so we don't have convictions. When somebody testifies that they have been tortured or otherwise ill-treated, there are 2 avenues, and that's what happens in practice. The court will normally say, either I'm actually going to address this in the judgment, whereas before the judgment, the verdict is reached, we don't know what the prosecutor does. The prosecutor is going to rely on the evidence. The parties will examine the evidence in court, and then later, very much later, at the end of the trial, are we going to find out whether whatever was used was evidence. Because inadmissible evidence is not evidence. And inadmissible evidence should not even reach the judge. The judge should not hear or see the inadmissible evidence altogether. Or the court can discontinue the proceedings, send the allegation of torture to the Special Investigative Service for investigation. In a sense, this can be considered positive, but it's self-deceit by the courts, because it's not candid. That referral is not candid. If you candidly expect a finding of the facts of torture by the person, most people actually benefit from the presumption of innocence too. So you're going to expect the fact of torture to be proven in a separate set of proceedings. You expect the person to be tried, convicted, and then you can pick up the judgment, and then you can declare the evidence is inadmissible. And if this cannot be done, then the judge cannot wait for years for the new judgment. I asked the judges, how much can you wait before prosecuting a case to be initiated, to be prosecuted? If a person has committed a crime, and you need to have evidence that torture was committed, you're going to wait for years for the torture case to be completed. This approach of the court there would be a decision to discontinue the prosecution based on which then because of the absence of the facts, they will rely on the judgment. If it's conviction, then the judgment becomes final, so you cannot go after the police officer or the perpetrator of ill treatment and hold them personally liable for a crime, because the judgment has already been issued based on the allegedly illegally obtained evidence. So it's a situation of limbo, as opposed to trafficking cases where we have seen progress. In torture cases, victims only get compensation if the torture is proven. If there's evidence that a crime has been committed towards a victim, if you don't have somebody convicted, the victim will not get any compensation. But this contradicts the international conventions, because the victim is a victim of a crime, not a victim of a person. So the state is obliged to compensate the victim, irrespective of whether the perpetrator has been identified and convicted. But we had the Convention on the Compensation of Victims of Violent Crime, which has been in the Parliament since 2001, but then after 10 years or so, the President pulled it out of the Parliament agenda. Victims could seek compensation through civil proceedings, but this was eliminated. And that convention is no longer in the agenda of the Parliament. Anyway, to cut a long story short, I'll allow my colleagues to say more about specific cases. So if you have questions, we'll be here to answer. Thank you, David, for the overview, for showing how this relates to the right to a fair trial, for showing how we need to look into specific areas. We have monitored specific areas. We have found certain problems. So I'm going to ask Mr. Arthur Sakund to speak about impunity in the police and elsewhere. Thank you. I do welcome all the participants and thank you for your interest. For your interest to this very important issue. And it's really related to one of the fundamental rights, the right to be free from torture and inhuman and degrading treatment. I will not go into the details of what the Committee Against Torture has found or published in its initial document. There are some questions to the government which I'm going to talk about. But first of all, I want to share with you the impression which I got as a citizen of the Republic of Armenia, as a representative of a human rights organization, the impression I got from these meetings. Let me confess, there's nothing new in what we were discussing there. Neither anything new for the representatives of the government nor for us. It was just that we can find that in the committee we presented what we have really not done so far. There was no issue that we were unaware of, that we would just find out about while we were there. But there was one thing. We spotted we have not been active towards these problems we had. We did not show government delivering against its commitments. We could not see the efforts made to address the problems caused by degrading treatment by the police and for reducing the risks of degrading treatment by the police. And I'm referring to taking people to police stations and basic notification of rights orally and in writing.
When people are brought in to register, then provision of proper legal assistance, communication with the relatives, phone call, rights to phone call, the right to examination by independent doctor, and proper documentation of this. And then issues related to not keeping people more than 72 hours. Actually, the committee says that before 48 hours are up, the person should be brought before a court in order to decide on the detention or further detention. Is there any issue here that we hadn't talked about before? In our daily activities, in many of our reports and publications? No, of course. I do apologize for interruption. A car number 00501. If it's your car, please move it. So we went to Geneva and we met with members of the committee, as a state representative, as part of our shadow report. Then the representatives of the state answered questions from the committee, and some of you saw it on live broadcast. And then we come back with the same baggage of issues or problems. We could have already met here and found solutions to these issues. And we're going to go without resolving these issues because, for example, if we had proper investigation of police action during March 1st events, the Human Rights Committee and the Committee to Prevent Torture had already talked about this, and then these things would not have been raised again. So in other words, we don't do things and then we go there and the civil society will, of course, present the objective picture and representatives of the government. People who are not responsible for the whole system, but people who find themselves in a very bad situation, because it's people who don't do things that should be responsible. They have not done, and not other people. And all of the questions or issues that are raised by the committee talk about impunity. And when all these questions are repeated, or issues are repeated from report to report that indicates impunity. When it says that, as Mr. Khachatyan mentioned, there is no proper or effective investigation of allegations of torture, that indicates impunity. The committee talks about the effective examination of deaths in the army, but that's not new. We have been hearing this many times. We have talked about this many times. We could be accused of raising a lot of issues and questions that go against their national interest, but this is not the right approach. When it comes to the whole philosophy of state responsibility before its citizens. And trying to could have said in the committee meeting that fighting against torture is against national interest, but that's not what they say there. They say that here on TV. Fighting against impunity requires a lot of will, a lot of persistence. Rather, it's nothing but simply implementing the laws that are on the books already. I'm very sorry that we have the situation that we have, because impunity leads to continuous violations of human rights. That should not take place in any civilized society. And so we would like very much for this conversation. Of course, there's many different issues that need to be discussed. We would like this conversation to continue so that we can find solutions together, rather than just meeting each other in courts and in press conferences. But we want to work together to achieve, to address the situation. We want to take steps to address the situation. So that the comments about not doing certain things become more positive. Of course, they do talk about some positive changes as well. For example, criminalizing torture in the criminal code, but the problem is in practice. We need to practice the application of the laws, because we are real people and we live a real life. We cannot live in the laws only. The laws are there to be applied, and from the point of view of applying the laws, we do have a problem, and the issues related to the military or to the police remain the same over and over, which is unfortunate. And taking this opportunity, I'd like to urge, as a citizen of this country, I urge law enforcement agencies, the prosecutor's office, the courts, to implement their commitments before citizens of this country by prosecuting people for inhuman degrading treatment in order to overcome this chronic impunity. We can achieve this, and we want this to happen, and we are ready to support in achieving this goal. Thank you. Thank you. Mr. Sakuns, I think you didn't believe what you said, that this argument can be believable even for the person who says it, that fighting for dignity and for rights may in any way harm national interests, because because it is also a human right to live in a safe and fair country, which is also the national interest. I just wanted to make sure that you understand that this is not an acceptable argument. The foundations and the partners have also been persistent about the following, which was recently recognized as torture, is not relieving someone's pain if you can actually relieve it, not treating pain, not taking measures to relieve pain has been considered torture recently, and we're happy to report that Armenia signed to this UN convention. Unfortunately, also, we're happy that some steps have been taken. A strategy has been developed. Uh, the ministries of Justice, Finance, and Health have already approved it, the strategy on palliative care. It is included in the government's agenda. We are hopeful very much that the strategy will be approved and will have the legal and practical foundations to change the situation with policy and with medication, to change the situation for people who suffer from extreme pain. About problems and solutions in this field, I would like to ask Ms. Violeta Zopunian to present. Thank you. I would like to thank you all for being here. And thank you for including this important issue of palliative care in today's agenda. If we talk about pain and relieving of pain, the relation of this to torture or inhuman treatment, I think this connection is very obvious, especially when we deal with patients that have cancer, HIV, AIDS, cardiovascular diseases. Very recently, WHO published some information according to which 80% of cancer and AIDS patients experience extreme pain, and they need their pain relieved. There is a 1 to 10 scale for measuring pain. Anything more than 7 is considered to be extreme pain. 67 of the 80% that were mentioned, they experienced this kind of extreme pain. This is a very serious problem, and when Human Rights Watch organization did a study in Armenia for their regular report, they visited many patients, and we saw a lot of situations that are nothing but torture and or inhuman treatment of these patients. The situation in Armenia is such: every year, about 15,000 patients need palliative care or pain relief. According to our legislation, which covers this area, is the following. So I'll tell you what we have and what we have achieved so far. In 2009, for the first time, palliative care was included in the list of medical services as a separate type of medical service. Then other documents were developed, the legal foundations, in order to streamline the legislation. Then a concept of palliative care was also developed, which was approved by the government. After that, the legal acts on licensing were also brought in compliance with this legislation, so that all medical organization or medical guidelines and medical documents for palliative care are properly approved, legally speaking. After that, a problem arose because of the actual laws and the medical services that are provided in practice. After a few documents were adopted, we realized that the practice is still not working properly. In polyclinics in particular, I'm talking the symptomatic treatment of cancer patients. What is the procedure for providing painkillers? Patients or their family members, if the patient themselves cannot go to polyclinics, they go to a polyclinic. And please pay attention to the fact that not only cancer patients need pain medication, but patients with other diseases also need pain relief. But according to our legislation, in order to get strong painkillers, you need to have oncological diseases. So you have to be an oncological patient in order to get strong pain relief. That's also problematic in the law. So very briefly, I'll tell you step by step how the process takes place. The patient and family member, they go with their documents to a polyclinic or medical institution. They form a committee made up of different specialists, which include the chief doctor, the physician of that patient, the oncologist. They visit the patient, they make a decision on the type of painkiller, and they start with the minimum dosage. Regardless of the extent of the pain syndrome, they prescribe the minimum possible dose, and then they gradually increase the dose. And very often the patient actually doesn't survive. The patient dies in an undignified way by going through a lot of pain and suffering. And this is a problem not only for patients but also for family members. When we visited these patients with human rights watch organizations, we saw things that I wish nobody would ever see. And solution that is offered at the moment is the adoption of two very important laws and actual application of this legal document or laws in practice. It's the only way to address this issue. In addition to complicated procedures, we also have some artificial obstacles that are created especially by law enforcement agencies. During our meetings and during our work, we've seen a lot of cases of medical personnel saying that there is very strong control by the law enforcement agencies over prescriptions and the patients who receive types of medications every month. You have to inform the police about this. You have to give them all the information. If you change the dosage, you have to notify the police. This is an obvious example of people not doing their job properly. So the doctor, instead of just treating the patient, has to do all sorts of other things as well and talk with law enforcement, etc., which makes the whole pain treatment process much more difficult. Also, Palliative care and pain treatment does constitute torture and inhuman degrading treatment, and Armenia has ratified the International Covenant, where Article 12 talks about the right to health, not only in the light of treating the diseases, but also talks about the patient being able to live life normally. When the pain syndrome is more than 6 or 7 on a 1 to 10 scale, the person is unable to live normally anymore. The person cannot do anything anymore with that kind of pain. And in countries where palliative care has been introduced a long time ago and where they have proper pain management, people who are diagnosed with these diseases, they still spend the last few years of life working. They are socially active. They can communicate with other people. They live their life to the fullest extent possible, and they die in dignity. We have a serious problem with that here, and we're talking about 15,000 patients a year. That is quite a big number, I think. Problems that exist in palliative care, the two important documents, the adoption of which would answer a lot of questions, are the following. The strategy, it has been ready since 2014, has been circulated, has been amended. 2014. So this strategy needs to be adopted first, and second, the procedures for medical use of narcotic medication should be adopted. In the past, it was an annex to a law or decision, and now it's developed as a draft government decision. It's waiting for final approval. So these are the two legal solutions to the problems. And from the practical point of view, from point of view of practice rather, we need to educate medical personnel who are involved in the provision of these types of services, and most importantly, the interference of law enforcement has to be minimized. We understand, of course, that law enforcement agencies have their own functions and they have to do their job, but their job has to be, their interference should be proportionate and it should not harm patients. Their interference should not harm patients who die in terrible pain. That's all for now. Since we are running a bit late, there'll be no comment or questions at this moment. I'll give the floor to Avetik Ishranyan. He will talk about the excessive use of force in the context of freedom of assembly. Thank you. First, I wanted to say that our organization is doing regular monitoring of assemblies since 2008. Armenia was the second after Moldova where such monitoring took place. And we do regular monitoring of all assemblies, and then we publish reports about this freedom of assembly. I wanted to read excerpts from our 2015-16 annual report and our ad hoc report about the July events. Now, we often talk about proportionate or disproportionate use of force by the police. There's always this discussion whether the use of force was proportionate. I wanted to express a bit of a disagreement with only this as an option. Unnecessary use of force, and then when the use of force was legal or lawful, only then we can think about whether it's proportionate or not. Because our monitoring shows that it's not that the force that was used was proportionate or disproportionate, but the use of force was completely unnecessary, unlawful. So it's not the question of the force being proportionate or disproportionate, but often it's the question of unlawful use of force. Our annual report was published in July. It covered about 130 assemblies, and during a number of these assemblies, there was some interference by the police and use of force. Often, what the police representatives do is this. They often themselves provide arbitrary interpretation of the law on freedom of assembly. For example, the law says that the authorized body can forbid an assembly or a rally that has been notified if it's taking place within a specific distance of the president's office, the courts, or whatever other agencies, or if the rally threatens the constitutional or other rights of other people. The police interpret this provision themselves. And they often prohibit assemblies or use force against the participants of the assemblies, but there is no decision of the authorized body about the distance. For example, the police is not particularly active in front of the National Assembly, but that's a whole different issue. But the use of force, I have many examples, but in order not to bore you too much, let's look at April 22, 2016, and the police interference with that assembly. This was the most unprecedented and disproportionate decision by the police. The number of police officers was significantly higher than the number of protesters. A strong force or brutal force was used when arresting people. A journalist was also arrested. And this was an arbitrary, unlawful use of force. I can give you many other examples. Where we had the events in July, during the events in July, I'll just read you a couple of words from our monitoring reports. Our monitors or observers they follow the rules of ethics. They're supposed to be completely impartial, and they have to report only what they see themselves, free of political influence. On the 18th, the members of the citizens' initiatives were preparing to do a public discussion on Independence Square. There was a number of our monitors there, including myself. Police officers started arresting people in the place of the assembly, and then restricted the movement of the participants of the assembly. The assembly was completely peaceful. I haven't seen that kind of brutality in a long time. The police officers simply attacked people and started beating them up and arresting them. And there are many such examples. I wanted to give you two more examples. I don't know if something has changed. I'll give you one very old example. I wanted to talk about this. In 2004, there was an administrative court proceedings. Two young people distributing leaflets in favor of Eduard Khachaturian or something, and then they were arrested. During the trial, the judge asked two officers, what did these young people do? Actually, distributing leaflets is not a crime. The police officer said they were distributing leaflets. The judge got angry. He said, I told you that distributing leaflets is not a crime. What did they do? And they looked at each other. The police officers said that they were distributing leaflets. And the lawyer said, what did you do when you told them to remove their leaflets? Said they removed. So both of them were fined by the judge for not following the lawful request of the police. Often people are arrested for not following the lawful orders of the police, but we'll see if anything has changed. A year ago in July, I went as a monitor because it was kind of late in the evening. I didn't want to bother everyone. There were big demonstrations in Gyumri against Permyakov, and no more than 40 people in Yerevan were watching the demonstrations in Gyumri. And then police officers in civilian clothing basically started kidnapping people. I approached them. I said, who are you? What are you doing? They said they were the police. I asked for the documents. Nothing. I approached Mr. Movsisyan from the police. I said, the people are being kidnapped and then the police is not doing anything. Then we talked a bit and then I was arrested myself. After 2 hours in the police, they took me to write down the protocol. I said, I'm not going to sign anything. And they said, aren't you interested why you're arrested? I said, yes, I'm interested. And they said, not following the lawful orders by the police. But I told them that even if their demands were unlawful, I would have followed them, but there were no demands. What happened in July? They would arrest people from their homes to prevent them from going to the demonstrations. There are many examples of people being taken to the police academy, people being beaten up without any reason, or people taken to Ashtarak police and then being kept sitting on a chair for 30 some hours. That's really torture. It's not even inhuman degrading treatment anymore. So these were the unlawful use of force examples, but as for proportionate or disproportionate force, on the 20th, the mob started throwing bottles and stones towards the police, some people from the mob. In such cases, the police has to use force, of course. It has to use force against people who throw bottles and stones. And what the police did, they attacked everyone, regardless of who those people were. So they started using brutal force and explosives. So instead of using proportionate force against people who were throwing stuff at them, they use force against everyone. So that use of force is disproportionate. Also can remind you the Electric Yerevan cases where more than 200 people were arrested, kept more than 9 hours, but the way they were treated, etc. And unfortunately, as already was mentioned, the main problem is impunity, because the police, instead of following the laws, they follow instructions, and those who give them instructions cannot then instruct the others to punish them, because they all follow instructions instead of following the laws. At the end, I wanted to read another section. I actually read it during a press conference, but I think many of you have not heard it. It was an Armenian officer in Armenian police uniform.
գրականության, հայկական, վերջապես հաջողությունի մասին, որի համար նկատի կերպով բոլորովին ներուն է, որ ազգից է, ինչ համազգեստունի հակիմանի ոստիկանը.
For the people, it doesn't matter what nationality the police officer comes from or what police uniform he wears. This was a quote from Anterian, who's a 19th century writer. I missed half of it, I'm sorry. I promise not to make comments, but I think we cannot ignore this. We're talking about resistance to representatives of the state or not following their orders. There is a presumption that representatives of the states make lawful demands, and then the members of the public they'll have to prove that they're exercising their civilian rights. For example, Article 164, I think, of the Criminal Code talks about disrupting the professional and lawful activities of the media, as if the media activities can be professional but not lawful. Ms. Snisakan is here. She has done a lot of monitoring and she has taken a lot of these cases as a lawyer. So if you have a police officer in civilian clothes, then everyone has to believe that he is a police officer. But if the journalist comes and says he's a journalist, nobody believes him yet. So there is always this presumption against the journalists and civil society, and who have the burden of proof of lawfulness of their action. But then when Lucine Saikan, for example, the defense lawyer, questioned the lawfulness of the police action or the police demands that the person, the defendant, allegedly opposed, she said, how do you know your activities were lawful or their demands were lawful? Then the judge also said that we're asking, and now we're questioning the witness rather than checking the legal knowledge of the police officer. So if the courts are independent, then a lot of these issues can be addressed properly. Then the judge would have said there is no probable cause. And on this note, I would like to give the floor to Artak Zeynalyan. He will talk about administrative safeguards against torture. Dear colleagues, about a week ago, the Armenian government lost to civil society in Geneva, as was defeated by civil society in Geneva. We're not happy about this at all, and we don't think that we're unable to address these issues here ourselves. External objective observers made the assessment that the civil society was right and the government representatives did not pass the test. Is it not possible to make sure that we civil society representatives raise issues here in Armenia and then get resolved here in Armenia, so that we don't have to resort to extra national? I think it is possible. We should be able to address these issues in this country, and we have the right to do so under the Constitution. It's the right to participate in state and local government. When people, even in a minority, raise issues before or questions before of the government, one of them can and should be addressed in the country. And they should result in set of rules and procedures that would be binding for everyone. This is a characteristic of a democratic society. And I suggest that such a national mechanism should be introduced, and it should work not only when Armenia is a respondent in international arena, but this mechanism should be used much more frequently. No, I think we should suggest it to the Council of Justice and then try to introduce this mechanism, because the people of Armenia have formulated their interest in the constitution, according to which officials acting on behalf of the people in the Republic of Armenia have to ensure human rights, including the right to remain free of torture and inhuman degrading treatment. My colleagues already talked about this. What does it mean? That the Armenian government is required to ensure the right to remain free of torture and inhuman degrading treatment. They're supposed to protect that right. They have to be legal safeguards, legal protection mechanism, rather than a person trying to protect his rights. There should be extrajudicial and judicial measures and protection measures. I would like to talk a bit about extrajudicial mechanisms in Armenia and their viability. We already talked about criminal law, now let's talk about administrative law a bit. Armenia has an international commitment to ensure that there are legal remedies in place, including judicial mechanisms or remedies and administrative remedies. Are there any remedies for the protection against inhuman degrading treatment? In theory, yes. In 2004, the law on administrative proceedings was adopted. It went into effect 9 months later. It went into effect nine months later. In order for certain procedures to be adopted, some training and awareness raising to take place, or secondary legislation, for secondary legislation to be adopted. In December 2004, this law went into effect. According to this law, state agencies are supposed to then receive and process complaints that also are related to interference with the right to remain free of torture and inhuman degrading treatment. So, in other words, you can ask this or that body, the state body, to recognize that the actions or the interference by an official from that agency has been unlawful, or it constitutes violation of the right to remain free from torture and inhuman degrading treatment. So in theory, that remedies there. Article 104 also talks about pecuniary and non-pecuniary damage compensation. In theory, it's all there. But the right or the law, the right becomes a right when it can be exercised in practice. Otherwise, it is illusionary and abstract and not real. In Armenia, We haven't had any cases of administrative proceedings by which the police would consider any of its actions unlawful or would provide a person with proper and adequate compensation in extrajudicial way. Why this compensation is important? Even if the violation of the right is recognized as such, that's not enough for the protection of the right. In order for full protection, a person is entitled to fair compensation. A person needs to be compensated for its material damages, such as, for example, lost income, but also a person has to be compensated for moral damages, emotional damage. What does it mean? Often the government says that the person couldn't prove that he or she experienced moral damages. This is very typical to all governments, regardless of the type of flag that they have, regardless of the type of uniform that they have. This is typical to all governments. They always say that you did not prove that you experienced moral damages. And then finally, the European Court had enough of it and responded to the governments that if the rights have been violated, it's not up to the person to prove that he or she experienced moral damages, because that is already automatic. So they tried to close the mouth of all the governments. Of course, the governments use this argument, but know that if your rights have been violated, there is no way that you could not have experienced material or non-material emotional damage. In 2011, on September 21st, human rights defender Levon Barsevian tried to do a free or peaceful assembly to express his disagreement with having foreign flags waved at the Independence Parade. He was arrested. Now he's been removed here again. And we asked the court to recognize the violation of his right. The process took 2 years. In 2013, the court ruled that his rights were violated. And then we tried to continue the process and then seek fair compensation. The court of the first instance decided that the police should compensate Levon Barsevian. Of course, the police ignored it. We went back to a court, and the court decided on a compensation of 200,000 for his non-material damages, and then 300,000 for the court expenses. The violation took place in 2011, but the court decision is still not final. Can we say that this process is effective? No, because delayed justice is denied. Is justice denied? And in the law that I already mentioned, we don't have the possibility of compensation of non-material damages in case of inhuman degrading treatment. So therefore, it's against the interest of the people, as mentioned in the Constitution, and it's not in line with international commitments. There is a problem here as well. So with our current legislation or litigation, we're trying to set precedents so that people can protect themselves. In the Shilverix versus Russian Federation, the European Court mentioned that this compensation for this type of damage is extremely important for officials to know that they will not be left, that they'll be held responsible for violations of human rights. A car 1745 license plate needs to be moved. Thank you, Mr. Zeynalyan. Mr. Zeynalyan has had a lot of work litigation and compensation of moral damages. I wanted to also recognize High Colombian's contribution in the cases against torture. The first case, Harutyunyan versus Armenia, and the victory in that case. Of course, victory doesn't mean that the other side lost, because this was also the victory of the state, because a lot of things have changed and they will benefit the state. And Mr. Aluman, I think, still has a lot of work to do and will have more victories in the European Court. Thank you. According to the agenda, I'm supposed to talk about specific cases of torture. I'll give you only one case where there was a variety of torture in that one case. I'm talking about Vahan Shirkhanyan. Many of you, if not all of you, know who Vahan Shirkhanyan is. He used to be the Deputy Minister of Defense in Armenia, and he used to be Deputy Prime Minister of Armenia. The reason I mentioned his former positions is this, because this is a message to today's government officials, saying that he's asking people to be quiet in the background. So those who are in government who are violating people's rights in their position, they should not think that they will remain in that position forever, and they should not think that they will be the ones deciding whose rights can be violated and how. This should be a message to them that if they do not help us protect human rights, the same weapons will be used against them one day. As you all know, many of you know, Vahan Shirkhanyan was arrested in December 2015. Was a healthy 68-year-old man in good health condition. He walked very freely and he was quite active physically. 4 months later, after 4 months in detention, he received infarction of the lungs because his health complaints went without attention in the penitentiary. They ignored his complaints about his health so much until he got a serious condition. With a lot of difficulty, they were able to save him, but he remained in custody. Even though we're not discussing this particular issue today, but they continued to keep him in custody without any legal grounds for it. But that's a whole different story. So a person who was in good health before detention, he is now unable to move without assistance. It will be 4 months already since he cannot shower. That's a whole other story. Imagine you haven't had a shower for 4 months. You cannot have a shower for 4 months, and nobody cares. In his cell, he uses cold water because there's nothing else in the sink, and then tries to keep himself clean. That is very difficult for him. 8 months. For 8 months, he hasn't been out for a walk or exercise. This walk is extremely important. because that's the only time, 1 hour a day, when you see sunlight or natural light. So he hasn't seen the sun for 8 months because he's unable to go physically. He's unable to go to this walk. They have to take him, but nobody takes him, and he cannot go by himself. 8 months. If it's not torture, then what is? He has now very serious problems with his blood vessels. There is no specialist on blood vessels in the penitentiary service. The prison hospital doesn't have specialists in blood vessels. So his problems remain untreated and they become more exacerbated. He has received more than 4,000 pills so far, and having taken 4,000 pills, not only his health didn't improve, but his health condition keeps getting worse every day, despite 4,000 pills that he received. If that's not torture, then what is? A well-known figure, a person who's played a very important role in the government, in the establishment of a state, and for some reason a person who's become uninteresting or not useful by the government for whatever reasons is now being killed slowly. And I'm using these words intentionally because every time I see him, his condition is worse and worse, significantly worse. So he's being killed slowly, right before our eyes. And I don't want to look at all the reports about Armenia. They're all appropriate, and, but I look forward to see what the reports will be on this case in the future if those people who are responsible for it do not start behaving properly. Now there is the trial taking place against him, and he's physically unable to attend the trial. He has to be brought in on stretchers. Even if they bring him in a wheelchair, he cannot sit more than 20-25 minutes because he experienced a lot of pain in his legs because of the blood vessel problems. So he's unable to attend the trial, and they don't bring him in a stretcher. On December 2, the trial was postponed. The next one is on next hearing in January. If they don't bring him in on a stretcher, then they will keep postponing the trial until they reach the goal, which is to have him die in the prison. Ara Garagazan is here from the monitoring group. He's seen Mr. Shekhanyan as part of his duties, and unfortunately, every time he says that his condition is worse than before. That's it, as an example of what is happening today. Thank you. Mr. Alumian. One of the commitments before the Council of Europe is to prevent threat of torture. In this case, we have a threat of torture, or torture. The torture is there, but there is a threat of losing a life. And if the person loses his life, or it's just a matter of time before the person dies, And then we'll have to deal with, the violation of the right to life. Now I'd like to give the floor to a representative of the Ministry of Justice. If there are any, then
մենք օրակարգը ովքեր որովհետև պետական պետության ներկայացուցիչները դեռ չեն կառավարության որտեղ
representatives of the government or the state have not necessarily confirmed their participation. Is there anyone from Ministry of Foreign Affairs? Anyone from the penitentiary service? Then the police. As far as I know, we do have participants from the police. No? Special Investigation Service. Mr. Varjan Garamanyan, please. Thank you.
Yes.
First, I would like to thank Party for Open Society for this initiative. The majority of cases in a special investigative service are opened on a basis of reports by society organizations or information provided by them. And they also always follow up with their cases, and they're always interested in the cases. And a couple of words about Special Investigative Service and some statistics. I think you might find that interesting. Special Investigative Service in 2014, in second half of 2014, starting from the second half of 2014, has three specialized departments: Department Against Torture, Department of Cases of Corruption, and then General Department or General Crimes Department. In the case of torture, in 2012, we had one case. Then that case continued in 2013. In 2013, we had 16 cases. In 2014, we had 78 criminal cases. And one case was sent to a court. In 2015, we had 100 and some cases, of which one case went to a court. In 2016, in the first 9 months, we had more than 90 cases, of which 3 cases with 6 defendants were sent to a court. I wanted to say that our colleagues talked about Electric Yerevan and the cases related to Saritach, the cases in July. So all of the cases, in all of the cases that we opened, we have 4 police officers have been charged, and their cases are now pending in court related to Electric Yerevan. In Saritach cases of July of this year, a number of people were charged with interfering with journalists' activities, and 7 cases with 14 defendants have been sent to court. If you have any questions, you can ask me now. Nothing else to add. Before we get to questions, I suggest we listen to all the presenters, and then we can ask questions to anyone. I just told you about statistics on cases related to torture. So the question at the end. Now, representative of the investigation committee, for me. Welcome. I welcome everyone. Thank you for inviting us at this discussion. I'm from the investigation committee. I worked in Yerevan investigation committee as an investigator of especially serious cases. I heard all the issues that you presented. I will talk about the issue that is related to our activities. Article 6 of the Law Investigation Committee says that we do investigation of specific cases that are within our mandate, and the majority of the issues that were raised here are outside of the scope of the investigative committee's activities. The main issue that is related to our activities is about investigation of deaths in the army in times of peace. And I wanted to inform you that I talked about this issue in during the presentation of the Armenian report in the UN in 2012 to 16, the time that was covered by the report. Some reforms took place in this area to ensure independence of investigation. As you all know, in the past, such types of cases were investigated by the military investigative authorities that were part of the Ministry of Defense. After the Law Investigative Committee was established, when the Investigative Committee was established, this part of the Ministry of Defense was moved into the Investigative Committee. It became part of the committee that was removed from the Ministry of Defense. And the head of this department is now the deputy head of the Investigative Committee. And so that reform took care of the independence issue. So this department now that does this investigation is no hierarchical relationship with the Ministry of Defense. As for the investigation of criminal cases related to death in the army in the time of peace, I don't want to give you the whole statistics for 2014-16. I will talk only about two pieces of information. First, there are 81 cases of death in times of peace in those 2 years or 3 years. 72 criminal cases, 72 cases there was a criminal case open, and in 20 of these cases the person will have been convicted. I don't want to talk about the whole statistics right now. I presented the statistics in Geneva. If you're interested, you can watch it online. As for criminal cases about improper relations between military six ended up with a criminal case. In 500 or so cases, we submitted or we charged this person. So it wasn't conviction, but it was charges were brought against the person, indictment rather. And, this shows that there's quite a lot of cases that ended up in court, which an indication of an objective investigation and comprehensive investigation. That's all I plan to talk about today. If you have any questions, I'll be more specific then. Thank you. Do we have someone from the National Assembly? Would you like to add something? The human rights defenders representatives. First, I thank you for your invitation. I'm Deputy Head of Staff of the Human Rights Defenders Office, Vladimir Hovanesyan. In the past, I worked also, I was actively involved in the activities of the Department on the protection or prevention of torture and human degrading treatment. We heard different opinions about the healthcare in prisons, including the right to healthcare and medical services. With your permission, as for Mr. Shirhanyan's case, the human rights defender made a decision by where he found a violation, and the human rights defenders provided detailed assessment that was provided to the person. As for torture, I wanted to talk in general about the subjects that were discussed today. As for torture, in 2015 there's been some progress. We're talking about criminalization of torture and making that definition of torture more in line with international documents. So these steps have been taken. However, there's still a lot of work to be done. You know that the human rights defender is a national prevention mechanism for prevention of torture and human degrading treatment under the convention. The parts of the Human Rights Defenders Office who are doing this MPM functions, they visit regularly all closed institutions, including prisons, police stations, police departments, psychiatric hospitals. An issue related to arresting people during demonstrations and protests. The human rights defender went to Constitutional Court on this issue of arresting people during demonstrations, and he's questioned the constitutionality of certain provisions of the law on that subject. So the case is now in the Constitutional Court. Other issues that we talked about here were about roads being closed as a result of an assembly or a demonstration. We're talking about Electric Yerevan in particular. In this regard, during all demonstrations or protests, the Human Rights Defenders Office representatives, including our Rapid Response Department and the Department for the Prevention of Torture, do joint visits to different police stations. They examine the issues, the problems. We talked to people who have been arrested. We looked at the protocols. And all of the issues identified by us are then reflected in the annual report by the Human Rights Defender. About the issues discussed today, that's all I think. If you have any questions, I'll be more specific. Mr. Alumian, a short response, and then Mr. Bisharian from the Prosecutor General's office will speak. I should have said this. The only government agency that has met all of our expectations on Shirkhanyan's case, that did everything that they could, was the Human Rights Defender's Office, for which I'm very grateful. Not on my behalf, but on Mr. Shirkhanyan's behalf. The Human Rights Defender addressed or discussed the issue in great detail and made a very proper decision, and he suggested that Mr. Shirkhanyan should be moved immediately to civilian hospital. But it's been 2 months since that decision by the Human Rights Defender's Office, and government agencies have not done this, have not carried this out yet. Thank you. Mr. Alumian, Mr. Karen Bisharian from Prosecutor General's Office. Thank you. First, I would like to thank you for this initiative and for inviting me. This event is very important. As for statistics of the cases of torture, Mr. Aramanyan talked about the cases that were opened, the cases that were sent to court, how many people were charged. So I don't want to repeat what he had said already. I wanted us to the following. Traditionally, when the issue of prevention of torture is discussed, we always start talking about how many people were convicted of torture, and usually civil society representatives, lawyers will say that it's a problem that very few people are being prosecuted for torture. But let's not forget another important thing. We're all aware of the European Court standards on the effective investigation of torture, allegations of torture. What the European Court says that a proper and effective investigation of torture is an investigation of not necessarily results, but it's an investigation of the means. So of course, proper investigation will have to result also in prosecution. It doesn't mean that what I'm saying here doesn't mean that identification of culprits and then prosecution of the culprits is not important. All I wanted to say, though, if our main criteria is the number of people who have been prosecuted, then we would not be quite as fair. Yes, the number of people who were prosecuted or is quite low. In 2014, I think there was one case with 3 defendants. That was in Gerharkunik Court. The case was tried in Gerharkunik Court. And these 3 people have been convicted under Article 309, Paragraph 2 of the Criminal Code. Next year, in 2015, only 1 criminal case was sent to court with 1 defendant. We still have no court decision on this. The case is still pending. In 2016, we have already 3 cases with 6 defendants, that are now pending in court. There's still no final court decision. The trial is now ongoing. The Prosecutor General's office realizes that the prohibition of torture is an absolute prohibition, and the Prosecutor General's office is doing everything it can to ensure that the standards for an effective investigation of allegations of torture are implemented, including standards that the European Court has arrived at in cases against Armenia, Virabian versus Armenia, Albandian versus Armenia. And in both of these cases, the European Court has found specific violations, and the Prosecutor General's office pays a lot of attention to these issues raised in those cases. The Prosecutor General's office has met with civil society organizations, including one very recently. We have admitted ourselves that we need some mechanisms to overcome the problem of proving cases of torture, because we do have difficulty proving torture cases. The standards of proof are high. Standard of proof is high, but the standard of proof is difficult, is complicated, because we have a lot of allegations of torture that took place a very long time ago, or the person cannot provide objective information about the alleged torture, and the investigators cannot find any objective proof because there is no signs of torture on that person. So in our meetings with civil society organizations, we've asked for some recommendations from them. The agreement was reached that they will send us the recommendations in writing. This could be recommendations about amendments to the law, or recommendations about investigative methodology or changes in procedures. The next thing I wanted to talk about, what Mr. Khachatryan mentioned, again about the standard of proof. This question is related to the judges' activities. For example, when judges keep postponing the trial until the fact of torture is confirmed in the Special Investigative Committee. We've discussed this with Mr. Khachatryan. I know what his approach is. He's using a lot of the American models. The American judges, for example, they never wait for the conviction on torture. This is a model, but it doesn't fit into the current legal system that we have. So we cannot admit evidence into trial that is received under the threat of violence, deception, etc., etc. If the law says alleged violence, threat, etc., etc., then our judges could have make a ruling in their cases about admissibility of evidence received with alleged torture. So, but now, because there is no word alleged there, they have to wait until the final decision of the other proceedings to confirming that torture took place. We have specific criminal cases where, under which people used alleged allegations of torture in order to get some evidence thrown out, but then the case of torture was not confirmed, and a person was prosecuted for perjury also. Our process of proving the evidence is not ideal, of course. We haven't reached the ideal where we prove that either torture took place or the person has provided false testimony. Because there is no ideal, then the rule is that if you have suspicion, like any suspicion can be or should be interpreted in favor of the defendant. I did not hear what Mr. Zainal said, but Mr. Zainal said that the government lost to the civil society organizations, but you realize that this is not the place where you win or get defeated. It's not that platform. Both civil society organizations and the government or the state are not out against each other. They're not enemies, and we all have the same goal. At least the Prosecutor General's office has the same goal. Thank you. Thank you. And since we have quite a lot of time, I'm sure you have a lot of questions. And since Mr. Visharian also talked about our discussion, I will briefly talk about my position on this issue, and then you can ask your questions. I'm abusing now my power position of a moderator. Yes, the American model. It would be nice if it was applied in Armenia, because it's quite effective, but it's not the issue of it being American. For example, in Kafkin versus Germany, there was a violation, unlike Misharchina's case. Why? Because the court cut the poisonous fruit chain, because the court threw out the evidence. And then Gavkin then confessed to the crime in the court. And that is the difference between Misha Harutyunyan's case, Saikolman's case, and Gavkin's case. Because in our case, the European Court mentioned specifically that before making a court decision, no separate decision on admissibility of evidence was made. So that jeopardizes the case. Also, the Rabyan's case was mentioned. In the Rabyan's case, there was not only procedural violation, but also other types of violation. The government actually said that the court says that the Rabyan was subjected to torture. And as Mr. Visharian mentioned, the convention doesn't require you necessarily to find the culprit, but it requires you to take steps that will lead to potentially finding the culprit. For example, there was a case when a woman was allegedly undressed, and then the case is closed, and then there is an appeal. But the court's wording was very interesting. When the closing of the case was appealed in the court said the decision, removing the decision to close the case would be a violation of presumption of innocence of perpetrators of torture. That would never happen if you go there with another case or regular case of theft or anything like this. when the case is closed, and then the victim goes to the court to course that decision. No judge would ever say that if I course the decision, this was the violation of presumption of innocence for the perpetrator.
There are some other aspects to present as well. But the one case that was mentioned in 2014 was the General Department of Criminal Intelligence case. So anyway, we all acknowledge that the statistics are also showing us that if there's a ratio that you look at, the ratio of reports to charges is a striking difference in torture cases versus other cases. There are cases, of course, if you look at 1,000 reports of theft or 100, you don't just get one case. From 96, we had one torture case. Please be brief so that the audience also has some time. Thank you. Just a brief pattern. In the mass event, if it's 500 or 1,000 people, about as many police officers, the number of criminal cases charging citizens is a lot higher than police officers acting in illegal conduct 1 or 2 or a year later, or in prison. Drug trafficking prosecutions. The number of cases towards detainees or inmates a lot higher than the number of cases against prison staff. Phone smuggling into prison, or phone possession inside prison. Look at the penalties. Sanctions upon inmates and sanctions upon prison staff. I mean, if you just look at the pure math, nothing to compare. Nothing to compare. The number is a lot higher. More cases of prosecution of citizens than of officials. Or look at Electric Yerevan or the July cases. While there is credible evidence on video and there are facts, all you need to do is just act. You don't need to study this much longer. Finally, Mr. Bisharian, the famous Seviranov case. The guy was charged with 17 episodes of theft. The court of Armenia, even the court of Armenia, acquitted him. And 16 episodes of theft. The police officers report or the report of violence by the police officers concluded that no crime has been committed. So the person really confessed to 17 episodes himself. Either this person needs to be checked, tested. At the time of confessing, you need to make sure the person was actually culpable. Or there are problems with the investigation authority. The court also makes a decision, and the court says the police officer also benefits from the presumption of innocence. No, they don't. State officials are subject to the presumption of guilt. Because a representative of government is likely to abuse. And the government has to investigate duly to dispel the suspicion. The state has to prove that this has not happened. You need to prove, and the state doesn't have to prove currently that such things have not happened. Thank you, we share your opinion and everything else, but my personal opinion is that there's no presumption of guilt. What I was saying is that discontinuing the prosecution does not raise any questions of presumption of innocence. Presumption of guilt can be negated only by a conviction. Questions of guilt can only be addressed in the conviction judgment. Here, without going into much theoretical detail, if you'll allow the audience take the floor to introduce yourselves, please ask your question briefly. We have 1 hour 20 minutes, 1 hour 10 minutes more. For interpretation, please use the microphone on either side, if there's no microphone there. Please introduce yourself and ask the question. Thank you very much for allowing me to participate in this meeting or discussion. First Vice President of the Armenian Technological Academy, member of the Public Council. I have difficulties speaking Armenian, so if I switch to Russian, forgive me, please. I have a few questions on these presentations. The first question on the court trials. There can be errors in courts and investigative actions. There can be errors in the convictions. Why is it not possible to have jury trial in Armenia? I think it would reduce the likelihood of these errors. And that's my first question. Second question. What about the behavior of the police and the other law enforcement agencies and demonstrations and the like? I think it happens because they do not know human rights. No one in the police is familiar with human rights. Of course, ignorance of the law will not excuse anyone from liability. So in those institutions, one needs to have very clear selection, and knowledge of human rights must be one of the conditions. These officers are obliged to defend human rights and not just to violate them. And that's the second question. My third question is this. You spoke about medical practice here in the institutions. Whatever it's called, prisons? Anyway, the prisons, treatment of the inmates. Why is it not possible to make sure that the independent medical agency twice a month comes and visits and checks treatment and the condition of all the inmates? It can be done on a voluntary basis. Doctors Without Borders, for example, they go to Syria. Doctors Without Borders should be able to go into our institutions for inmates and check them twice a month. We need doctors to visit these institutions regularly. That will guarantee us against all violations, bribes, and the like. Another question. I need a minute. You said that there are observers in demonstrations. From the Ombudsman's office or for some other organizations. Why not give them an observer uniform? Yeah, you want them to get beaten up as well. It's double-edged sword. Demonstrators and the police officers need to be able to recognize these people, so the demonstrators don't get beaten up, the ombudsman doesn't get beaten up. I think that's also a question that could be dealt with. And finally, but that's probably not related to this meeting today, I very much regret that the Civil Society Commission is inactive at this meeting. In our public council, the cause of all our troubles is not violation of the law, it's that the people do not know their rights in most of the cases. As a filmmaker, a former Soviet television employee, I would ask you to reinstate the human rights education programs on television so the public knows what rights they have and what offenses are. Thank you, that's all. There's a lot of questions. It's really the most legitimate court jury trial is. Common sense is brought to court in that way, but you also need to give people the right to carry weapons. I think it's Tolstoy who said good people need to come together because bad people have done it a long time ago. The bad guys have done it a long time ago. So the people that we need to be protected from need to have weapons. All those other people have weapons. I'm not saying everyone who has a weapon is a threat to people, but those common people should be protected. They already have weapons. I also think weapons are missing. Of course, there will not be political trials. It's presumed that for the cases of the 1st of March, I did a lot of monitoring. The judge asks, 3 police officers come and testify that the person resisted. And he says, well, it's the first time I see this police officer. The prosecutor says, well, then you're telling that he's lying in court? So this guy is trapped between either somebody has to be lying, you're cornered. All 3 police officers must be lying, otherwise the defendant is lying. Well, the defendant is getting convicted anyway. It's about the burden of proof. If I don't believe the police officers, it's a higher burden of proof. A lot of questions, so let's not go into details. What is your answer about? What's your remark about? About assembly, Mr. Ishkanyan. Should briefly present it and then you can go next. There's a microphone, there are microphones around the room. About the police officers not knowing the legislation on freedom of assembly. In 2009, I was invited by the U.S. Embassy experts to go to speak with the. And let me just say that there were 3 types of police officers in the room. One type, the minority, of course, were aware. Another part, about half of them, understood after they heard. The third half didn't care, couldn't care less. But that was 2009. But I know that the OSC, with its best experts, Neil Jarman and the others, have had peaceful assembly seminars for a lot of these senior officials. The police commanders, many of the senior police commanders in demonstrations are very well aware. Some of them are quite well aware of the Armenian legislation on peaceful assembly, peaceful rallies. Now, knowledge is very important, but unfortunately, the police in Armenia are not mainly following the law, but instruction. There's an order, there's an instruction they follow, although they know the law. Our studies have shown that sometimes they comply with the law very well. Defending a rally, then there's a much more peaceful rally, and then all of a sudden the police, the same police officers, become very brutal, apprehending people, the same police officers who are knowledgeable of the law. So it's about following instructions, not so much a problem of knowing the law. As to the observers, they all actually carry visible badges. The police mostly know our observers. There was the one case where Mofsisan knows very well we're an observer. He knew very well we are observers, but I can tell you a long story about why I was arrested, apprehended, taken to the police station. We asked him how the law was violated. A lot of people were there. He just didn't know what to say. He was trapped. I think he just had an order, and now he's explained that he's breaching the law. There were two other cases as well. During electric caravan, one of our observers was caught. Then they saw his badge, they released him, let him go. In Sari Tagh, one of the observers had the camera seized, but then he showed the observer badge. The camera was returned. Thank you. Ombudsman's office, please. Is that you? And then Lucina. Jean Alexandria wanted to speak. I just wanted to make a comment. I have to introduce myself again. I'm a public officer. I work in the staff of the Human Rights Defender. I'm also a postgraduate student of criminal law and criminal procedure law. So I study criminal procedure with deep specialization. And a very good question was raised. I want to thank information about the administration of justice in our culture. In Mahitar Ghosh's code of trial and elsewhere, there was always public involvement in the administration of justice. The Soviet Union did the same. The German Chauffeur Court concept was brought in. It was called popular trial or layman court. When two laymen were on the bench, it was so effective that in the years of the Soviet Union, most of the procedure scholars were opposed to it. I have evidence showing that the vast majority were opposed. In reality, creating and keeping jury trial is ineffective. It was ineffective, yes. It's costly and it's time-consuming. There were two contradictory statements in your speech. First of all, you said that the majority in society have very low legal awareness. And then you proposed having jury trial. Well, of course, that's very much a contested statement as to what the level of legal awareness in the public is. But we still have to get there, and I have to say with pride that we have drafted a new code of criminal procedure. The Ombudsman is one of the members of the group that drafted the new code. The code has become a very strong document. There are independent opinions from Europe as well as Russia who are saying that in post-Soviet area, this is an unmatched draft code. No one else has a draft code that is as good. A second comment, in order to avoid a misunderstanding, I think our colleague is thinking that the ombudsman's representatives are getting apprehended or beaten up in demonstrations. Not at all. As to our uniform, we do have some insignia, and carrying or not carrying the insignia is decided on the spot. We have our tactics, and we decide whether or not to carry our insignia at any given time. And as for personal activity, we are protected by law. We're all protected by law. But this, well, we have some official privileges. Under the law on the ombudsman, we cannot be apprehended or investigated for reasons related to our work. David, sorry, I want to remark briefly as to the Soviet era layman bench trial. You may be right. In Soviet years, this was superficial, but in the years of independence, it suddenly started to work. I can guarantee you, I want to tell you an example. In 97, when there were political trials, 96, for those who were arrested in 96, there were jurors in the Supreme Court. And I can confidently tell you, in those cases, when they started, after 9 months of jailing people, to release them, the two lay judges played a crucial role. I can assure you, they refused to sign papers sending innocent people to jail. And I think that the lay judges were eliminated for that reason, among other reasons, because representatives of the public, unlike the Soviet era, when they were superficial, had started to be effective. The public defender concept also was becoming effective, but it was eliminated too. If I can just add very briefly, I absolutely agree with you. And the 95 Constitution made it possible, but over time, legislation was not enacted. The Criminal Procedure Code was not appropriately amended to make jury trial possible. I'm not opposed to jury trial. I am for jury trial, but I think that it's not time for it yet. It will be premature here still. Let's be brief so we don't drag this on too long. We're going to talk about torture. Jury trial maintains social balance. It's for the police. Remember the O.J. Simpson case keeps the police under some sort of balance, and it's also for politics. Let's just do brief remarks. Arthur Seconds, then Jean Alexander. To continue what you said, it was under the previous constitution, but it wasn't done. The constitutional provision is not binding for the government. If it's in the constitution, it actually requires legislation to be enacted. I should tell the representative of the public council that in Sir Sargsyan's concept for the constitution, jury trial was going to be introduced. But even he did not comply with his concept paper. The public council should have asked Mr. Sir Sargsyan why he's not following the concept paper. If he raised something in the concept paper, that's great, but he should also explain why he was not following through. As to the medical checkups, some changes are now proposed with respect to the prison health service. There have been proposals to make it completely independent, but I think they have come up with some interim solution. There's a deputy head of the penitentiary administration here who's in charge of the prison health service. He can talk about it if he likes. There's an interim solution, not a final solution right now. As to the police not knowing about human rights, Mr. Ishkanyan already covered this. I'll cover something else. We're suggesting that the police educational institution, the police academy, provide some education on the discrimination culture, on fighting discrimination, to inform police officers about discrimination. We have letters. The chief of the police concluded that it's inappropriate for police officers to get human rights training. This is in public letters. We can provide copies. We can ask Mr. Gova Gaspayan, why are you opposed to police officers being aware of human rights in greater detail? Having heard the speakers today and having heard about the current situation, how this is all presented to the international community, I fully understand that the problems of the police are related to the police. And I don't know if there is anything to contain, to restrain the police, for the torture not to magnify. Mr. Bisharian spoke about torture. I get the impression that the prosecutor's office is not very much protected against all of this. In our meeting, you shared some statistics. You said about 100 cases, criminal cases, had been initiated. Not a single one had been solved. I think that was this year or last year. So what should be done? What needs to be done for the police to be more on their toes, to be more contained? What would you say? Mrs. Alexanian, in numerous cases we have investigated the reports when for the Special Investigative Service, we have really lowered the standard for initiating prosecution. In a way, even deviating from the law whenever we get a torture allegation. For other cases, for other types of cases, we have a higher bar for initiating prosecution. For torture, we do initiate prosecution in almost all the cases. That's one of the reasons why we have investigated a lot of cases. So people make a report, we always initiate a criminal case because we can carry out proper investigation once we initiate a criminal case. The large number of initiated criminal cases versus the small number of people actually convicted in no way could give rise to certain concern. However, it is not a direct indicator that there were real cases of torture that went unpunished, because there are numerous cases of somebody just reporting a crime. When they are being tried, or someone is being tried and they are a witness in a case, so in a theft case, a burglary case, somebody who was a witness, who testified, described the features. After a long time, the case gets to court. In trial, in public trial, the same person is ashamed of testifying against the defendant. And in court, he says, oh, the investigator forced me to testify during the pre-trial investigation. And this is not what I really meant to testify. I was really not a witness to the crime. We have lots and lots of such reports, such allegations. So for these allegations, what would you expect the investigation to show? We don't have any prejudice that they are always recanting their testimony because they're afraid in court, but the vast majority of them are. And they're recanting because of pressure, public pressure, peer pressure. The number of initiated cases is large simply because We prefer to initiate a case and not to just inquire. We investigate, and we properly investigate after having initiated criminal prosecution. In 2016, we had 3 criminal cases involving 6 suspects indicted and sent to court. Let's give the floor to Mr. Alumian for a question or a remark. Please. Mr. Bishayan said apparently there was only 1 case, torture case, sent to court last year. Is that correct? Was that 1? Well, I believe that's the Armavir case, right? Is that the Armavir case? Well, it wasn't torture, Mr. Bishayan, really. The police officer just beat the person, but it wasn't torture. They just got into a fight in the street. The police used force, and it's good that one of the police officers has been charged with beating, and but that's not torture, you see. Torture is specific in a number of ways. You can't be alone as a torturer. There's torture, usually involves a lot of people, a lot of accomplices. It's usually done in a closed institution, such as a penitentiary institution, a police station, a mental health institution. Usually it involves 5 people, 10 people, they all see it, and they were supposed to do something, but they don't. And people are standing nearby and helping. People are on duty that day and are helping. We haven't had a single such case ever since the Misha Harutyunyan case. We haven't had a single case exposed of a person being tortured in a police station where the duty officer would have not acted or would have been an accomplice, having several people convicted to actually show justice is done. Yes, 1 police officer's case was sent to court because in the street there was a couple of punches blown by the police officer, but that's not torture. I think we're discussing something that lies a lot deeper. There's a much greater problem here because there is no one who has been punished for those types of cases. Mr. Alumian, I don't want to go into the legal subtlety, but allow me to disagree with you on that case. The charges have been forwarded to court, not under Article 309, paragraph 1, but 309, paragraph 2. However, that case, when it happened, I think 309 paragraph 1 was not in force yet. Moreover, I categorically disagree with you that torture requires several people or several accomplices helping each other. The convention definition of torture under Article 1 of the Convention Against Torture, which is almost literally copy-pasted into Article 309, paragraph 1 of the Armenian Criminal Code, provides that one of the features of torture is punishment. So infliction of strong physical pain or mental suffering, and goal. One of the goals can be to extract confession statement or to punish for an act. From this point of view, you might reconsider your approach to that particular case, but that particular case is not what we're discussing here from a legal point of view, but I categorically disagree with you that torture requires several perpetrators or helping each other out and so on. No, we're expressing our opinions. to try to present the reality. Some statistics in 2015, 12,657 criminal cases were initiated. 2016, 10 months, 10,662 cases were initiated. We have 12,000 cases, of which in 100 cases there were last year also allegations of torture. Subsequently, they were investigated. Let's look at the trend. I mean, that's about 8%. Is that a lot? That is a lot. But we also have duly investigated cases. There's always this presumption of failure in the investigation of cases. It's not a reasonable accusation. There's no one here at the police who could actually answer your questions, and I get the same impression that the lady there is getting, who said, I think the police are guilty. Of course, the police are not here, so let's blame them for everything. The police academy teach human rights. It's been for a number of years already. Maybe there was a different component or the element was reviewed, but human rights are in the curriculum. It doesn't mean that the police officers do not know about human rights. All the lawyers here would tell you, you know that they know the law very well, but you're thinking whether or not to apply the law. As Mr. Zainalian said, no knowledge doesn't mean that the person is going to apply or enforce the law. The person may choose not to enforce the law. I have two questions. One has to do with the intervention. If monthly information is given to the police, is that interference with palliative care? I disagree. If a doctor is treating a patient and the doctor is also prescribing medication which is narcotic or psychotropic, they just send information. The police officers do not interfere with palliative care. The second question was for Rabbi Gishkanyan. He left. You spoke about the special locations, special places, and determination of distance. Which state body is allowed to determine the distance for demonstrations? I believe it's the police. The police have the power to determine the distance, the authorized distance from state institutions. As to the so-called presumption of guilt, I just think that there should not be such a notion. The presumption of innocence is a fundamental right, and irrespective of the person's office, job status, or profession, every person should benefit from the presumption of innocence. We cannot differentiate or actually segregate between people based on public service or being a public official. And a final comment on proportionality. Someone earlier said there's selective enforcement of the law, presenting statistics on the number of disciplinary cases in different agencies. But if you have the same basis, the administrative body has to treat them the same way. But if the grounds are different, the factual circumstances are different, obviously the sanctioning decision and the actual sanctions will be varied, because punishment has to be differentiated and individualized. Thank you. For giving the floor to Arthur Seconds. It's not like we are accusing the police because they're not here. And it's not that we're only blaming them. They were invited. The fact that they aren't here doesn't mean that we're not going to express our opinion about their activities. The other issue is not a question of statistics. The CAT also noted it with respect to the high standards of proof, the evidentiary standard, that this balance between the number of cases initiated and the number of cases forwarded to court. It's a matter of principle. Even if the investigation were very diligent, judicial oversight in those cases is so poor that people say, well, I was tortured. The case is initiated, then you investigate it, and then terminate it. It depends on how it's presented. What do you mean? No. You know, Mr. Tomasyan, you said something. I can respond to that now. In the Silyanov case, or the Poshian case, where in Banazor, the guy was saying that in the police station he was stripped naked and he was searched. This person was searched. Well, now the person has the right to make this allegation, and the case will be investigated. We're not saying that necessarily happened. We're saying this is what the person is alleging. The case was initiated and then terminated. And the termination decision was appealed in court. Okay, so far so good. The court says if I eliminate that decision, and if I tell the investigator to actually continue the trial, then I would actually violate the presumption of innocence of the police officers. But as I said many times, it doesn't matter for the presumption of innocence. There's a court order. It's in the CAT set. Over 10 cases. There's also the Virabyan case, which I participated in personally, and Mr. Zainalian is also here. Of course, he has participated a lot more. Now it reads, torture has been committed. Okay, we're not the ones saying it. Sarkuns is not the one who's saying it. Or someone else. The European Court is saying it. Why is there no effective review? Moreover, there's a procedural violation. This guy was promoted. Let's not name him because there's, should we not name this guy because the police are not represented here? There is torture. I'm not denying that there's torture, but you keep citing an example where your one example or two or three examples are then used to reach general conclusions and to claim that that's universally the case. I'm suggesting you take a more comprehensive look. We had the Virabyan case and nobody denies it. We had a number of cases against Armenia, with a lot of decisions against Armenia, in fact. Those lessons were learned and actions were taken based on these decisions. Some people have failed, but there are good practitioners as well in any field. Could you say that everyone is acting in good faith? Of course not. So we're discussing the phenomenon here. I'm not accusing you of accusing the police. But that is my impression. That would be the impression of a neutral person. There's a public comment, and I'm replying to the public comment. I'm not arguing that what you've done is positive or negative. I'm just citing facts, and I'm having the facts discussed. Thank you. Can I just say a few things now? The police are guilty, and I insist. And I will continue to assert it. On the 10th of December, on International Human Rights Day, the Banazor police called individual citizens and said, do not go to Yerevan. That's a fact. On International Human Rights Day. It's not just the Virabyan case. In decisions of the European courts, in at least that case, or the Nalbandian case, was anyone of the police ever held liable? No, they were not. For the Misha Harutyunyan case, for the Khalapian case, when the person, I know the circumstances, but the person supposedly committed suicide in the police. He was later charged with, after his death, he was charged with beating the witnesses. And when I reported the violence, I was not prosecuted for perjury. The court concluded that the witnesses left. Why don't they charge me with perjury if that's the case? If I'm lying and there was no violence against the witnesses. I met with the witnesses lying in bed in hospital. were not even questioned in the criminal case. It's presented as the non-Khalafin case. We do make generalizations because the European Court itself says the government needs to make an effort, an effective effort to find the perpetrators. We're talking about the absence of the effort. With the criminal case, with the proceedings like this continued, we're seeing a lack of effort. There's violence against a priest by a council member, and I know about the case. The chief intelligence officer of the police says 2 or 3 members of the group have been identified. We found them at 2 a.m. The criminal case file reads, this is a private complaint, not a group episode, but supposedly an area where the victim and the perpetrator can reach agreement. So the police are covering up the crime, obviously. Group crime. There's a famous video, it's there. Many people have seen it. The torture committee talks about effectiveness. That's what it means. The European Court is looking into this. We're talking about effective investigation by the Special Investigative Service. It's not 1, 2, or 3 cases. It's 100 criminal cases initiated. I can assure you, in most of these cases, and I can tell you the exact numbers if you wish. I can present the exact numbers if you wish. Zona Generation says, by broad daylight, you should be violent against the police. What other facts do you need? And he's still serving in office. He's still the commander of the riot police. His brother used special means. Did he have the right to use any special means? There's an abundance of facts. First, to conclude this discussion, I ask the speakers to be brief, Mr. Bishan and Mr. Alumian. I'll be brief. We can talk about specific cases, and that will take forever. The Vida Bian case was cited. It was cited by Mr. Khachaturian. Mr. Khachaturian knows criminal procedure very well. He knows the evidentiary standards very well. And for some reason, he just chooses to emphasize that the European Court found the violation of the right to effective investigation as well as a violation of the right to a fair trial. For the non-lawyers to not be confused, let me also comment this. The European Court's evidentiary standard is different from the evidentiary standard in domestic law. Mr. Sarkins was asking about this presumption of guilt. In the European Court, the burden of proof is different. The state has to disprove something. For example, disprove that there was torture. Otherwise, torture is considered to have taken place. In terms of the evidentiary standard, the European Court also found a violation of Article 3. So, a fact of torture. So we need to investigate this case under the domestic standard, find someone guilty. Finally, in this case is currently, European Court, I don't know why you're drawing these conclusions. The case is still pending. Khalafian case was cited. In the Khalafian case, 2 police officers have actually been convicted by court. And I know that there's an appeal to the European Court. We can express our private opinions about whether or not there was an effective trial, but this case is already in litigation in the European Court. So the European Court will determine whether the right to an effective investigation was breached or not. Sorry, Mr. Zainalian, because I promised by Inhuman, and then just very briefly, on substantive law, I am not saying that the European Court has found a violation of substantive law, so the national court has to convict someone. It should serve as a basis for a case to get to courts. The European Court says there was a violation. Under its standards, it found a fact. Is that a sufficient basis for our court to look into the merits? Not necessarily to find someone guilty. No, I'm not saying that there should be a default finding of guilt. So everyone, and of course, we all have the right to an opinion. Every time we talk about torture, we shouldn't talk about it after the European Court finds torture. In all those cases, such as Mr. Inhuman and the others that were cited here, we were screaming here that there was torture. Nobody was listening to us. Nobody heard us. They're saying, oh yeah, of course, the European Court found torture. Now we're trying to look for the guilty ones. We need to respond properly. When we are shouting here, we haven't even gotten to the European Court yet. Right now we are shouting of torture towards Mr. Shirkhanyan. No, I ask you to look into it. I ask the distinguished office of the Prosecutor General to prosecute it now, because there is more than abundant evidence in the media already to prosecute. But the decision of the Ombudsman is already sufficient to prosecute, because there's torture against Mr. Shirkhanyan. Don't wait for us to win the case in the European Court and they say, oh, it's too late. We can't properly investigate this case any longer. The witnesses are no longer there. The evidence is no longer there. Do it now. As for the cases that have been tried by the European courts, because of the lack of investigation, Armenia lost 45,000 euros this year. No, the other 5 was different. 45,000 euros, that is. And in the Matavis case, there's something shameful. 2 people had been, for the brutal murder of 2 people, a number of people originally confessed it was them. But then, some of those people who confessed, it turned out they were not the ones who committed the murder. Then another guy confessed here, as and then there was an acquittal because those guys hadn't done anything either. I'm not going to say much else. I'm just going to say, what do you need to do to a human being to confess that he brutally murdered 2 people when he hasn't brutally murdered 2 people? And what do you really do to those people? This is never investigated. Now, should we really believe that there is an effective investigation, that you're doing your best? And then now you're saying, let's not investigate the individual cases. Let's not discuss the individual cases. Let's talk about statistics. And then you're saying, let's not talk about statistics. It's not an indicator. What do you want to talk about? Our success in fighting torture? No, we don't have any. So, as the speaker just said, the evidentiary standard, the burden of proof is different in the European Court from Armenia. When there's a discrepancy between the standards of proof, or the evidentiary standards, it's a situation that violates the convention. The evidentiary standard in Armenia has to be the same as the European Court's evidentiary standard. Otherwise it would be contrary to the convention and contrary to the constitution. We agree now that Armenia has a systemic problem related to the evidentiary standard. In the Kalashnikov case, the European Court directly said that if there's the situation where a person has confessed his guilt, and it subsequently turned out this person did not do it, then there's been torture. There's no other explanation other than the interference with the person being such that the person had to confess to something you hadn't done. And that's irrespective of whether the European Court found a violation. There has to be an explanation to these situations. There's a court decision acquitting the person, saying the person did not murder anyone, and it did not lead to anyone being punished for torture. This wall has to be broken. These are the undisputed cases. The Halapian case, the Misharitunian case, the Vilabian case. We've completed the heavy procedure, gotten to the end. We want a specific result that we can extrapolate as case law in the future and clean up the field. That's why we wanted. In the Halapian case, one person was convicted. One person was pardoned. We don't even know why, whether the person was. The fact that the person was ill-treated shows that a person who is convicted of torture, they cannot be released on amnesty. This would violate the rights. The victims often are not brought into the proceedings, and that in itself is a violation. This would be failure of Armenia to carry out its international commitments and the commitments under its constitution towards its people. Thank you, Mr. Zainalian. The cats specifically, the SP team specifically mentioned this for the Armenian delegation. They said this should not happen again. Conditional release or pardon or amnesty or statute of limitation. I'll very briefly talk. Tumasan disagreed on the provision of information and said that it's not interference. Well, the information that is provided does not have any legal. The information is provided on the dosage. The doctor has an obligation to provide an explanation as to why the dosage is being changed for every patient, and that itself is obviously is clear interference. Any other questions from the participants? That was great. Thank you very much. I thank all of you for your participation. Thank you for having your different opinions. This is a dialogue. It's important that we all can express our candid opinions. Obviously, if someone cannot change their opinion, then that's not their opinion. It's an order or an instruction. People engage in dialogue, then it's a legitimate opinion. That's an opinion that can also change. This is the condition for our dialogue. Thank you for your participation.